Good morning again, everyone. I didn't really get a chance to do a whole lot of the intro information about Lawyers for Vets or about this CLE, so I'm going to take a few minutes to do that right now. I hope everybody signed in on the sign-in sheets out front. You need to put your bar number on there if you want to get CLE credit for it. Also, if you look on that desk, there are some sign-up sheets for the 4 months remaining this year that we're still looking for volunteers for the Lawyers for Vets clinic. So if you've never been, we'd love to have you for the first time. I know many of in this room have been many times. Thank you, Susie. And so if you have a firm that you want to do it as a firm project, that's what we do a lot of months. So if you have friends that you want to get together and do a month, it really is a pretty straightforward and easy clinic. We have a lot of support there. Nora's usually there. I'm there. We have other folks from the VA there. So it's pretty streamlined, and we try to make it as easy as possible for our volunteers. So if somebody's never been there, you have any questions about it, or you're a little apprehensive, just stop Nora or I afterwards, and we'll be happy to talk to you about it. Many of you might see one of these on the desk. This is a new report that Nora put together. This month marks the 2-year anniversary of the Lawyers for Vets Clinic, which is hard to believe that we've been doing it for 2 years. And this is just, some of you might find your picture on this little document. Without a release, thanks. But this sort of just shows the impact that the clinic has had in the last 2 years. We continue to get phone calls daily to get appointments. It's a pretty self-sustaining project at this point. The VA does a lot to publicize it. We've had a great turnout with attorney volunteers, and we really couldn't do it without the attorney volunteers. But as you can see on this, the most popular areas are expungement, pardons, after that child support, and after that wills. We've sort of cut down on the consumer and the ID just because we weren't getting many appointments in that area, and to have an attorney come to just sit there for 3 hours and see if somebody shows up, it wasn't really an effective use of time. So if anybody has any, yes, right. So there's an 800 number that the veterans call. They are screened to make sure they're income eligible and to make sure that they're issue eligible. And assuming that they meet those burdens, then we put them on and give them a date and time for their appointment. Now, we don't publish where the clinic takes place, and we don't publish what time the clinic takes place because we don't want a bunch of folks just walking in. And I know there are other clinics. I don't know if in Charleston it's a walk-in clinic.
In the VA, no, I think they have.
Okay. But we wanted to know who we were, going to be seeing that day. I'm trying to think if there's.
The only other thing I'd say is that we do have an issue with veterans not showing up.
Right.
Please know that we send a reminder in the mail. We call the day before to ask if they're coming or not. So that we're strong about it, just because we don't want to waste your time either.
Right.
So, but we still do have a fairly high no-show rate. That we try to accommodate that when you're there, so that we can let you leave earlier if we know that they're not going to show. So.
We usually end up overbooking for certain appointments because we assume that a lot of people aren't going to show up, but there have been times where every single person has shown up on those days that we've overbooked, but we've always gotten out of there right around noon or shortly thereafter, so we make it work. So I'm going to talk to you today about expungements and pardons, which is our second most popular area. Yeah, if you look on the table, this is, and this is available at the day of the clinic as well. This is a guide put together by the South Carolina Center for Fathers and Families that is a very thorough guide that sort of goes over each type of expungement. There's going to be a few changes that will need to be made, and I'm going to talk about some changes in the law that took place earlier this year up at our legislature, and as well as one that took place last year that we haven't yet seen but involves victims of human trafficking. So, but that's not in this guide either. And as you'll see, if you look at somebody's criminal record when they come into the clinic, we have Catholic Charities there. They pull SLED reports at a reduced cost for the veterans. The veterans have to pay for it. It's $8 for them. It's normally $25 if you get it directly from SLED. So Catholic Charities is there, so they will have an up-to-date SLED report, because otherwise I don't know how you would advise somebody on expungement or pardon. So they will have a SLED report that you can review. I don't know has anybody here looked at a SLED report? Okay. They're not the easiest, most straightforward thing in the world. I am always at the clinic, and I'm a former public defender, and I'm used to looking at lots of rap sheets. So, if anybody has any questions about expungements the day of the clinic, I'm there. And I'm going to go over sort of some of the issues that we see a lot of. The thing about expungements is, I think if you don't have any experience in criminal law, you can still do expungements. There are a limited number of types of expungement, 9 or 10. And then the only ones that we really see are there's a very few number of those 10 that we actually see. So if you don't have any experience with expungements, it's a pretty easy way to, dip your toes in the water and volunteer at the clinic. So the first thing I do when I get somebody's SLED report is just sort of take a quick look at it and review what's on there. Things that I initially look for are null pros charges or dismissed charges. The reason being, in most cases, those can come off of a SLED report, and it's free for the veteran, which is a big factor here since we're dealing with a lot of folks who are lower income. Prior to 2009, dismissed charges were not automatically expunged. So a lot of people have a lot of dismissed charges on their rap sheets. It's shocking how many people have 10-page SLED reports, but really half of those are dismissed charges. And so those can all come off. And so if you're a veteran trying to get a job and your SLED report's 10 pages long and you can get it down to 5 pages, that really helps somebody, even if you can't clear their entire record. Sometimes it's just about making it as good as you can make it. So that's really the first thing I look for, and it's easy to just flag. They usually get 2 copies of the SLED report, one for them and one for you to mark up, so feel free to mark up one of the SLED reports. Often you'll see a charge listed without a disposition. That happens very often as well. And we'll go over sort of some of the techniques to try to discover what the disposition is, including looking in the public index for the county where they were convicted or charged. But even if you look in the public index, sometimes you still won't see a disposition, because if it's a magistrate charge, they may not show up in the public index. Also, a lot of folks will say, well, I never was convicted of that, I just paid a fine. So there's a lot of, changing of expectations and being like, oh, I'm sorry, that actually means you were convicted. So it's amazing how people don't really know what's on their SLED report or what their, previous convictions are. Another thing I ask is if they have any charges from other states. It's unclear how thorough SLED is when they're evaluating expungements, because it's up to SLED ultimately to approve them. According to an AG opinion, charges from other states will count against somebody getting an expungement here. I haven't seen this come up very often, unless they do an NCIC search, which I don't know why they would, and they're wanted for murder in another state or something like that. But it has not happened where a charge from another state's really come up. So the next step is then you look and see if there's any eligible charges. And we'll go over what the eligible charges are, and then you have to take a look at the timeline, when those charges took place, how much time went by after that charge. Many things are not going to be expungible. You may have quite a few dismissed charges or charges that are eligible for expungement, but then quite a few charges that are not eligible for expungement. So then you need to talk about a pardon and whether or not a pardon is the best way to go. And sometimes you just have to ask them why they want the expungement or why they want the pardon. Is it because they're looking for a job? Is it because they just want to feel, they've changed their lifestyle, they've changed their life, and they just want to feel better about it, and they just want some sort of acknowledgement that they have improved their life? And it really just depends, because expungements are expensive if you have to pay for them. They're over $300. Like I said, the dismiss charges are free, but for the other ones, it's a hefty fee, and a lot of these people don't have $300. A pardon is a little bit less expensive, but it has fewer benefits as well. And if anybody has any questions at any point, just shout them out.
Is the $20 per expungement per charge?
Well, you can really only get one expungement. So it would be, if it's dismissed, it would be free in most cases. There's one caveat. Like if it was a misdemeanor offense that was expungible, is usually, well, that's where it gets a little bit complicated, because some jurisdictions in South Carolina will only allow one charge to be expunged. Some jurisdictions like Richland County are a lot more lenient, and as long as they were convicted on the same date, they will count them as one conviction. So it really depends on who is processing that expungement. If it's the Fifth Circuit Solicitor's Office, it's usually one fee, which is $250 to the Solicitor's Office, $35 to the Clerk of Court, and $25 to SLED again. But if it's in another county, they may not allow that. So this is one of the many problems with our expungement law, but different people interpret the expungement law a little bit differently, and nobody's challenging that quite yet. I know there are a few AG, I'm looking at the person from the AG's office, but I know that this isn't the area that you work in, but there are a number of AG opinions dealing with expungement. So, but it's usually one fee in most cases. So, a couple years ago, prior to this change, an expunged record means if everything relating to that record was completely destroyed. There was no evidence that anybody was keeping regarding that charge. They changed that so that law enforcement and prosecution can keep it for a period of time so that they can defend themselves against any unlawful arrest litigation. Because previously, if somebody brought a charge against somebody for an unlawful arrest and it's been expunged, there's absolutely nothing that they could use to either defend themselves, and there's nothing that a person could use to really prove their case either. So it was changed to allow for that. It is not, it's not open for anybody other than for litigation purposes. So, and I don't know if that's going to need to come up in your conversations with folks. This year, the mugshot bill, which is Senate Bill 255, passed, which is mostly deals with expungement and not mugshots, but we'll go into that. But it expands expungements a little bit in the area of dismissed charges and Title 50 and 56 and local ordinance charges, which were previously ineligible for an expungement. And that goes into effect in 3 days. So court administration will be issuing new expungement forms that will reflect some of these changes. Okay, so this is my favorite category, which is the dismissed and null pros charges. What I've laid out here is basically the new provisions. If it's a general sessions charge and it was dismissed pursuant to a plea agreement, then generally you do not get the free expungement. How you determine whether or not it was dismissed pursuant to a plea agreement is a little bit tricky. If there are other convictions around the same date that something was dismissed, you can usually guess that the solicitor is going to consider it pursuant to a plea agreement. In the summary court, there is no, you can still get it expunged, but it costs you money in that situation. In the summary courts, even if it was pursuant to a plea agreement, even if you had 5 tickets, 4 of them were dismissed, and you pled guilty to 1, the 4 would be able to be expunged for free. And prior to Senate Bill 255, for whatever reason, Title 50, 56, and the county municipal ordinances were excluded from an expungement if they were dismissed, and that's DNR offenses, it's driving offenses, and then, of course, the county municipal ordinances depend on where you're located. So, for instance, if you had somebody who had a DUI from 10 years ago dismissed, you couldn't get it expunged, but in 3 days you will be able to if it was dismissed. Yeah.
Was in a court complex the other day about a criminal charge, and was talking to the solicitor, prosecutor, and he was flat out saying
Yes. For magistrate level convictions, in 3 years, assuming you don't get any further charges, you can get that expunged if it carries a penalty of 30 days or up to $1,000. So, yeah, and we'll get to that category here in a second, because really that's the only other main category that things get expunged in. There was also an issue with whether or not somebody was fingerprinted for a charge. With a lot of the summary courts, you just get a ticket, you're not fingerprinted. And they were saying that those were not eligible for an expungement. You will now be able to get them expunged if you were not fingerprinted, but you have to apply for the expungement. And this is pretty much summary court stuff is what we're talking about, because in general sessions, you're going to get fingerprinted because you're being booked into the detention center. So a great piece of this is that it does apply retroactively. So, you know, all the Title 56 and Title 50 charges, which there aren't that many Title 50 charges that I've seen, but like boating, reckless boating or something like that. But we do see a lot of driving offenses that are dismissed. So it will apply retroactively, but you have to apply for it. And there's also this last provision that really applies more to the mugshot piece of the legislation, but basically the clerks of courts and the court staff are required to remove these from their internet databases within 30 days. Yep.
That doesn't include the paid sites? So the paid sites, they want.
Well, so that's the other, you mean the, what do you mean by paid sites?
I've seen a lot of sites that take the picture off the court sites and then they'll send you a flyer saying, hey, I want your picture of
Well, we're going to talk about that because that's the rest of the mugshot bill.
Okay.
That is, in 3 days, no longer legal. So, at least not for pay. They have to do it for free. So, we'll talk about that too. Does anybody have any questions about the dismissed or null prost? This is the fun one. This is the one where you get to look at people's SLED reports and be like, oh, this gets to come off and this gets to come off. And it's amazing how many sheets of paper the SLED report might go down. It does take some time for these to be processed. You usually go to the summary court. If there were summary court charges, you go to the solicitor's office for all other charges. When in doubt, I usually start with the solicitor's office. At the back of this packet here, there's a list, the very last page, in Appendix 2, who all the expungement people are in each circuit to get in touch with. That's usually a good first place to start because trying to get a hold of somebody in a summary court is a little bit more tricky. But most solicitors' office, every solicitor's office has a staff person designated to do this.
And do we share this information with this?
Yes, you can. Mm. And I don't usually have enough copies of those to hand out to folks, but there's no reason why, you know, they're available online too, so. And often when advising the vets, it's, you know, depending on the type of interaction that you're having with that vet, you may just tell them, you know, these can all come off, just go to the solicitor's office and they'll handle it for you. I've said that to plenty of folks because there's not a whole lot you need to do. They just need to go in there and apply for it, and it should be pretty straightforward. I'm not going to spend a whole lot of time on these next few categories just because this isn't something that we're really going to see at the clinic. Somebody's done PTI, pretrial intervention. The charges have probably already been expunged from their record. But I'm just putting it out there so that folks know the different categories of expungement. And the law is a little unclear. Expungement laws were sort of pieced together over time, so they aren't super consistent. This one specifically says that you can deny ever having been arrested for the offense. Not every category says that, but I don't know if it's ever come up where somebody's been penalized for denying an arrest if it's been expunged. And PTI is usually run out of the General Sessions Solicitor's Office or sometimes in the summary court as well. Same thing with the next few. Traffic education program, they've probably already completed it, and these are no longer on their record. If you do see it, you might see it because maybe they didn't have the funds at the time to pay for an expungement through these. So, but you're probably not going to see these. Traffic education program really is for younger folks too. And the same with the alcohol education program. I always thought it was really funny that the DUAC and the DUIs were specifically excluded from the alcohol education program since they're alcohol related, but I guess it's not politically feasible to allow DUIs or DUACs to be expungible, although it is apparently politically feasible to get a criminal domestic violence charge expunged, and we'll talk about that too. Did I skip one? Okay. So fraudulent check is one that you're probably going to see, and you're probably going to see a list of them because most folks don't have just one fraudulent check. And I don't know if you all know what fraudulent check is. It's not as horrible as it sounds. It basically means, in most cases, that you bounced a check and you were not able to pay it within the 10 days or within any of the other opportunities that they gave you to pay it, and so you have this charge for fraudulent check. A lot of people, they start bouncing a check, and then they bounce another check, and then they bounce another check, and it's just this whole series of fraudulent check charges. So you'll probably see this. There is some move to expand the number of expungements you can get. Currently, you can technically only get one, although, like I said, in Richland County, they tend to allow you to get multiple ones expunged if they're all convictions on the same date. I don't know. Is that like that in Charleston?
I don't know.
Okay.
We wondered the same because I've seen people with multiple in one day that dismiss, and I just tell them I'm not sure if they're going to let you.
Yeah. Yeah.
I'm seeing one of the solicitors down there, as long as you don't do the same charge multiple times over a period of time. For example, public intoxication was one. They'll expunge that if it's the first time you've had it. Reckless driving, things of that nature, and that I think that's them just working with people.
Yeah.
So,
Because there's nothing in the law that says they can't do that, which your question, Susie, about the multiple fees, like,
I've also seen people say that as part of a plea deal, if you do an
Okay.
we'll give you the reckless driving on a DUI. And
wheeling and dealing, you know? So yeah, I mean, it's very difficult sometimes to advise people on what's going to happen in their case because it really just depends on which office is handling the expungement and their interpretation of what they're allowed to do. SLED takes the position that as long as they receive the order, they'll do it. They're not going to ask too many questions. I've managed to find some creative solutions to otherwise unexpungible things by working with Adam Whitsett, who's the general counsel for SLED, who is very open to talking to folks about exploring creative options. So it's somebody to keep in mind. There's a 1-year wait period, which means, and this is another thing that excludes a lot of fraudulent checks. So you have the conviction date for 1 year. After that, you're not supposed to have any other convictions to be eligible for an expungement. But like I said, with fraudulent checks, there's a series of them that get processed over time. So there's usually within that year, there's going to be a subsequent fraudulent check conviction, which means the fraudulent check charges are going to be ineligible. There is a move, I think I started talking about this, to allow multiple checks that were convictions that fell within a 60 or 90-day period, assuming that the restitution had been paid, to allow them all to be expunged. One-time shot to get multiple, so limitless, basically, fraudulent check charges expunged within that time period. I was part of this legislative committee, and there are people who testified over and over again about during a divorce, one spouse basically writing a bunch of checks on a joint account, running it down and walking away, basically. So there's this case that was decided a couple years ago. This is one of the possible creative solutions to the fraudulent check issue. Prior to 2010, the courts were allowing these third-party corporate representatives to prosecute fraudulent checks. They basically go in and present their case and couple of public defenders here in Richland County made a motion to dismiss for failure to prosecute. The chief administrative judge said, I don't know what to do. Let me talk to the solicitor. The solicitor said, I don't know what to do. This was Barney Gizet at the time. So they asked for the Supreme Court to weigh in. Supreme Court said that is the unlawful practice of law for non-attorney corporate representatives to prosecute fraudulent check charges. So creative solution, and I've known some folks who have brought a motion to reopen and dismiss for failure to prosecute for cases that happened prior to 2010. Tricky part of this is proving and finding evidence that it was prosecuted by a corporate representative and not by a prosecutor or a city attorney. But it's happened, and that's happened here in Richland County. I don't know if that would be something that could happen in other places, but that would really be going a little bit above and beyond, since it would require some research and it may not be discoverable anyway. So that's worked once at least. Conditional discharge. Again, this is not something you're probably going to see, because if they received a conditional discharge, that means it's probably already been expunged from their record. But just so you know, it's out there. Some people are under the mistaken belief that this is the only way to get a drug charge expunged. The general counsel for the Richland County Sheriff's Department thought that this is the only way you could get a drug charge expunged, but they could actually get the simple possession of marijuana expunged under the municipal charge expungement, but they thought that you had to do a conditional discharge for a drug charge. But again, you're probably not going to see this because it's already been removed from their record. So this is the other one that you're mostly looking out for, is the first offense misdemeanors or first offense criminal domestic violence charges. What you're not going to see on a SLED report is what the possible penalty of a charge is, and that's something you need to look for. Just because it's a misdemeanor, just because it's from a magistrate's court, doesn't necessarily mean it fits under the 30 days, $1,000. A lot of fines carry more than $1,000 or more than 30 days. Just because somebody was fined less than $1,000 doesn't necessarily mean that the ultimate total fine couldn't have been more than $1,000. So that's where you may need to bring a computer and sort of Google and find out what the penalty for that charge is. There's a 3-year wait period for these, which means no convictions other than minor traffic offenses. For criminal domestic violence, you have to wait 5 years with no convictions other than a minor traffic offense. So there's another AG opinion about what is a first offense. Is it a first offense of that type of crime? Because you can see first offense assault and battery or first offense CDV. Or is it the first offense that you've ever received? And the Attorney General issued an opinion saying is the first offense that you've ever received. I don't know if that's been challenged. And again, it is an AG opinion, so it's not necessarily binding. But that is how a lot of the different solicitors' offices are interpreting first offense. So, you know, if you have somebody with a fraudulent check charge and then 3 years later they have a CDV, even if they just want that CDV expunged, the only one they're going to really be eligible for is that first one that appears in time on their report, which would be the fraudulent check in their case. And as far as convictions, Title 50 charges will be eligible for expungement in 3 days. They decided to not include Title 56 still. I don't know what it is about traffic offenses. I think it has something to do with the 10-year driving record that the DMV keeps on hand, and they just don't want to mess with that. That's my guess. I'm not really sure why they don't want any Title 56 charges expunged. Youthful Offender Act is something you're probably not going to see either, but you might. Not too many people are sentenced under the Youthful Offender Act. You have to be between the ages of 17 and 24. It has to be a relatively nonviolent charge. I say relatively nonviolent because some of the ones that are listed as, you know, Class D felonies are sound pretty violent. So you'd have to look and see whether or not it was classified as violent under the code. And this one, it says multiple charges can be expunged if they were disposed of on a single court date. And there's a 5-year wait period for this one as well. The February clinic, is that when you guys came, when Nelson Mullins came? We had a young Marine who 11 years prior had, with a bunch of friends, broken into another friend's house, and they all got burglary third-degree convictions and larceny charges. This particular young man was getting ready to join the Marines, and he ended up pleading guilty. He got off of his probation early because he got into the Marines. So 11 years of service in the Marines, highly decorated Marine, served overseas, served in war. Just an amazing young man comes in, and he has this burglary third charge that he did not get charged under convicted under the Youthful Offender Act. It was a straight up General Sessions conviction. So we're currently trying to, our creative solution is to get him resentenced retroactively or under the YOA Act. While there's no actual legal authority to do this, we're going to try. Adam Whitsett over at SLED, again, this is a good time to call him in situations like this. You're like, what can you do? And he basically said, if you can get a judge to issue an order saying to consider it as youthful offender, even though it wasn't, we'll expunge it. So I was like, all right. Solicitor's kind of on board. They're not going to oppose us. So it's just a matter of waiting and seeing if the judge that originally sentenced him will agree. And that judge is Judge Russo up in New York County, I think. I don't know him, so I'm not sure what the chances are of that happening. But this is a good test case, because if anybody deserves to get a break in this situation, it's this guy. He's been in absolutely no trouble since. He's married, he has kids, and he just wants to get a job now that he's out of the military. Okay, so last category in this presentation is failure to stop for a blue light. I've never seen somebody who just has a failure to stop for a blue light on there. Has anybody seen that? I have no idea why they passed this, other than somebody's kid didn't stop for the cops. And that's the only, And the reason why I've never seen this is because you don't normally just have a failure to stop for a blue light. You've got the failure to stop for a blue light, and then you have the possession of a stolen car, and you have, the marijuana in the car, and so, yeah, you don't really ever see this. So you probably won't. If you do so, please tell me. Let me know, because I will take a picture of it, and I will dance. So that's it for, I'll go ahead and talk a little bit about the other category that's not in here, which is for victims of human trafficking. And so with these victims, their charges usually show up as prostitution charges, and they have convictions even though they were victims of a human trafficking scheme. Now, this is apparently a huge issue in South Carolina, much bigger than the news would let us believe. And this is more than just bringing in folks from other countries and tying them up and using them as sex slaves in somebody's basement. This is oftentimes just people who don't have any money, who need to make some money, and they get a pimp or somebody who basically says, go do these things, I will give you a few bucks, you got to give me the rest of it. So last year in 2015, they, I don't have a slide for it, but they stated that a victim of human trafficking can get their prostitution charges expunged. They didn't really list how you identify them as a victim of human trafficking, which is a little bit of a problem. Like, if you were a victim of a human trafficking scheme, why would they have prosecuted you? But apparently it happens quite a bit. The FBI is actually working really closely to identify who these victims are and to start bringing them, contacting them and saying you might be able to get these charges expunged. I don't know if we're going to see a whole lot of that in our clinics, but I feel like I need to put it out there just in case. So This is a little screenshot. This is, for those of you who haven't seen a SLED report, this is sort of what it looks like. And of course, I've redacted this guy's name. But this is a common issue that you're going to see, where this is a situation where there is no disposition. And you're going to see that quite a lot. And so what I did in that situation is I went to the Clarendon County Public Index. I looked up, you can either look up by name or you can look up by case number, which I've blacked out here. And then there'll be a screen that comes up with a bunch of different tabs. One of those tabs will be, I think, disposition. I'm not really sure what it's called now that I think about it, but you'll see it on there. It'll open up a new page, and then you can see whether or not there's a fine or a fee or if it was dismissed. Unfortunately for this guy, these top two charges were convictions, but this bottom one, this possession with intent to distribute some drug, was actually dismissed. So that was one that we were able to get off of his record. But this is one guy who had multiple charges with no disposition. So it's really kind of shocking how often that happens. This is from the same guy's SLED report. He had a lot going on. If they're null processed or dismissed, it's a good thing. Like I said, if it was prior to 2009, they don't automatically come off. If it's after 2009, they should have automatically come off of the SLED report. It doesn't always happen, though. So, for instance, in this case, this forgery charge, this is one where it's unclear whether or not this was pursuant to a plea agreement. Since they look like they're part of the same case, they have different court dates, but it's really unclear. But we filed the paperwork, and they went ahead and expunged that one for free. So they didn't really put up too much of a fight with that. So that's one of those things. There was something else I was going to say, but. All right, so that's going to sort of wrap up my expungement discussion. Does anybody have any questions about expungements? Okay, so what's often going to happen at the clinic is folks are not going to be able to get everything expunged off their record or anything expunged off their record. So the next best thing is a pardon. And you're going to look at some people's records. I mean, we've seen folks with murder charges. We've seen folks with armed robbery charges. We've seen folks with extensive sex offenses on their records, and you're going to pretty much identify those folks as not eligible for expungement pretty quickly. And so it's sort of about letting folks know what their options are. But the pardon process in South Carolina is pretty straightforward. And within the materials that I sent out, I believe I sent a pardon application as well as a template for a letter. Part of the pardon application is 3 letters of reference. So that was sort of a template that I provided for those reference letters. Gun rights are restored, but you still have to register as a sex offender. So most people come in because they want to have a gun again, honestly. So the pardon is a 3-part application process. There's a paper application that you can get online at the clinic. I will have many copies available for folks. It's a pretty straightforward application. You just put some demographic information in about yourself. You put in information about your charges. If you were ordered to pay restitution, you have to attach a certification that the restitution has been paid. The letters of reference are basically people who need to put in that letter, I support this pardon, or it's pretty, you'd think it'd be obvious, but a lot of folks just sort of say, like, John is a good guy or something. But it's really important they actually say they're in support of the pardon. And in the template that I provided, it has that in there as well. It's a $100 non-refundable application fee. I find that they're pretty good if your application is not complete or there's something missing, they're not going to just take your $100 and say sorry. They usually are going to give you a couple shots to make the application right, if for whatever reason it's not. A lot of times we just hand the applications to the veterans and say, you need to work on this, you need to think about who your 3 letters of references are, because they're not going to come to the clinic with those 3 letters. And then we usually reschedule them to come back once they have the 3 letters and once they filled out the application and gotten the certification. And then we sort of review their applications at that point. Our pardon hearings take place in Columbia pretty often. The process usually takes 7 to 9 months. The pardon board does an investigation on each applicant. They will pull all records from throughout the state, every area where the person had a conviction. They will get the entire police file. If somebody had a drug charge on their record and they're asking for a pardon, the pardon board is going to ask if they've gotten drug treatment. They are going to ask if they had an alcohol problem. So, you know, the clients need to be ready to answer those questions. There's a 7-member pardon board, and in order to grant the pardon, they have to vote 2/3 to grant the pardon, and about 60% of the pardon requests are granted, which is a great number. It's wonderful. And I think part of the reason why it's so high is because a pardon doesn't do much. I'll be honest, I'm not a huge fan of pardons. I do think they serve a purpose. I do think if you're trying to get a job and you have a pardoned charge on your record, it's easier for an employer to feel safe hiring you, because what an employer is concerned about is a negligent hiring lawsuit. But other than that, you know, it doesn't really do a whole lot. It restores gun rights, and you know, you're not able to be impeached on the stand with prior record stuff, and you know, it's really fairly minimally helpful, I find. And a lot of the people who come to our clinics for criminal record help are 60, 70, 80 years old, and they really just want to, you know, leave a legacy to their kids that they've sort of been reformed, and this is something that they can use to, you know, feel better about that. I don't know, maybe I'm a little bit too negative about pardons. I like that 60% of them are granted. I like that it gives people an opportunity to have something they can present to an employer that says the state has forgiven me for this crime. Another thing to note about pardons is it's not just one charge that the board is considering. The board is considering your entire record. So a pardon is a pardon of the person, so not so much the pardon for the crimes. So it's a pardon is an all or nothing thing. So you can't go in there if you have like a CSC with a minor, criminal sexual conduct with a minor charge, and say, oh, I'm not trying to get a pardon for that. I just want a pardon for all these other things. They're going to be like, no, no, that's not how it works. I went through that pretty quickly, but does anybody have any questions about that? Yes, sir.
They've got a charge from another state. Is that, I'm assuming that would have to go through that state to get a pardon?
Yes. And every state has different laws about both expungements and pardons. South Carolina is one of the more lenient pardon states, and actually one of the more lenient expungement states as well, compared to our southern neighbors. Like most states, you can't even get dismissed charges removed from your record, which seems self-explanatory. If you were found not guilty, you shouldn't have that used against you, but other states don't think that way. So South Carolina is a little progressive in this area. But yeah, the out-of-state charges won't necessarily, it may impact your pardon rights for South Carolina pardons, but they're going to know if you have other charges from other states too, and that's one of the questions too on the application. They are, I think it's one at-large person and then 6 folks that the governor appoints from across the state. And this pardon board is also the parole board. They meet off of Divine Street. And you know, if you ever want to sit in on a pardon hearing, they're technically open to the public, although I've sat in on pardon hearings. They're very interesting, especially if this is something that you think you're going to do a lot of. Just to sort of, I mean, it's 5 minutes. You appear before the pardon board. They ask you a couple questions. Why do you want this pardon? Do you have a drug problem? Do you have an alcohol problem? Have you gotten treatment for those problems? The longer amount of time that's gone by since your charges, the better your chances are of receiving the pardon. There was a guy when I went to witness who had a 60-year-old bootlegging conviction. And they were just like, of course you're pardoned. Do you have any for us? You know, like, so it's kind of fun. I mean, it's, you know, and you find out right then and there whether or not they've granted the pardon. They kind of have these secret little buttons that they push underneath their desk, and then they tell the person before they leave that day whether or not they received it. And if they're denied the pardon, then they can reapply in a year. The one thing you don't say when you go to the pardon hearing is, oh, I didn't do it, they railroaded me. You know, I've seen that. Those people don't get a pardon. There's some, you know, it's interesting what they decide to pardon, what they don't decide to pardon. Like, there was a young man who had some charges when he was like 17 or 18 years old. He was graduated from USC and couldn't get a job, and they didn't think he was, I guess, sorry enough. It was their conversation that they had afterwards. And I was like, so it's kind of like, if you present yourself poorly, then it's not going to go very well for you. But that goes for a lot of things. So, yeah, don't say you didn't do it and then they railroaded you. So, yeah. Did you have another question?
They have a, I don't know, look for, do they have a public record of what they have and haven't pardoned and how they're...
There are some statistics available. I don't know how much they break them down, but they'll show how many people have applied and how many were granted. They don't show the charges, I don't think. They might. No, I don't think they do. I think they do for parole. They'll list the different charges, but I'm not sure if they do. I don't know. I don't know for sure. But if you go to the probation, parole, and pardon services, website, you have to dig a little bit for their statistics, but they're there somewhere. They might be a couple years old. They don't update them super often. So, any other questions? I encourage anyone, even if you're not super familiar with criminal law, to try expungements, because, and I'm always there to help, and it really is pretty straightforward after, you know, as long as you know what to look out for and the pitfalls to look out for. But, so I think we're going to take a little break now. I think we have a 15-minute break, and then Jeff and Mary will be up to talk about child support. Thanks.